Federal marshals move after First Lady's stunning testimony triggers emergency Supreme Court action. In a development that has sent shockwaves through Washington and financial markets alike, a dramatic and unprecedented sequence of legal events unfolded this week after the First Lady of the United States delivered hours of sworn testimony before the Supreme Court in what legal scholars are already calling one of the most consequential constitutional confrontations of the modern era. And within mere hours of that testimony concluding, federal authorities executed sweeping asset seizure orders, targeting properties, financial accounts, and business entities allegedly connected to an ongoing federal investigation into executive authority and the limits of presidential immunity. A move that has ignited fierce debate across the political spectrum and raised urgent questions about the balance of power, the sanctity of marriage under the law, and the reach of federal enforcement. Mechanisms in cases involving the highest levels of government. According to publicly filed court documents in this fictional scenario, the High Court had agreed 2 weeks prior to hear expedited arguments over whether certain frozen assets linked to individuals close to the president could legally remain restricted while appeals were pending. And at the center of the controversy was the issue of spousal privilege, as prosecutors argued that the First Lady maintained signature authority over multiple financial accounts allegedly involved in transfers that occurred after a judicial freeze order had already been entered, a claim that defense attorneys fiercely contested as both procedurally improper and constitutionally dangerous. What stunned observers was not merely that she appeared, but that she chose to testify extensively rather than invoke privilege protections, answering direct questions from the justices about her awareness of financial movements, her role in authorizing documents and the timeline of internal communications. And when she concluded, the court entered an emergency closed conference that reportedly lasted several hours before issuing a rare same-day order authorizing immediate compliance reviews and temporary seizure actions designed to preserve assets pending further litigation, a speed of judicial response that historians note is extraordinarily uncommon at the Supreme Court level, particularly in matters touching the executive branch. Federal marshals were then dispatched to execute domestic aspects of the order, securing properties and freezing accounts tied to the contested transactions, while international components required coordination with foreign authorities. And although the enforcement actions were described by officials as procedural safeguards rather than final determinations of wrongdoing, the optics alone intensified an already volatile political climate, with critics decrying what they described as judicial overreach and supporters defending the actions as necessary to prevent potential asset flight. Central to the unfolding drama were documents introduced during testimony that allegedly demonstrated discrepancies between what the First Lady stated she had been told regarding the legality of certain transfers and what the court orders actually required. And, in her sworn statements, she maintained that she relied on legal counsel and signed documents presented to her as routine business matters, only later discovering inconsistencies that prompted consultation with independent attorneys, a move that legal analysts described as either prudent self-protection or calculated positioning depending on their political perspective. Immediately following the testimony, filings referenced potential referrals concerning advisors who had allegedly structured the transactions. And although no final determinations had been made, the mere suggestion of accountability extending beyond principles to professional intermediaries sent ripples through the legal community, where practitioners began openly discussing the chilling implications of aggressive enforcement theories targeting counsel in high-stakes constitutional disputes. Meanwhile, political reaction was swift and polarized, with allies of the president condemning the testimony as compelled under extraordinary pressure and warning that compelling spousal testimony erodes centuries-old protections designed to preserve marital privacy, while others argued that privilege, like all legal protections, may be waived voluntarily and that transparency under oath strengthens rather than weakens democratic institutions. Constitutional scholars appeared on major networks dissecting the nuances of testimonial privilege, asset forfeiture standards, and the rarely invoked emergency jurisdiction of the Supreme Court, explaining that while asset freezes are not criminal convictions, they function as powerful tools to prevent dissipation of contested property while courts determine ultimate legality, and financial markets, ever sensitive to uncertainty, experience short-term volatility as investors assessed whether the confrontation signaled deeper institutional instability or merely a contained legal dispute. Behind the headlines, thousands of employees at properties subject to temporary enforcement actions faced uncertainty regarding operations, payroll, and continuity, underscoring that high-level legal conflicts often cascade into real-world consequences for ordinary workers. And economic commentators emphasize that regardless of political allegiance, the rule of law process would likely unfold over months or years, with appeals, evidentiary hearings, and potential legislative responses all on the horizon. In Congress, several members announced intentions to hold oversight hearings, examining executive asset management practices and the broader implications of compelling testimony from close family members of sitting officials, raising the prospect that the judicial clash could expand into a multi-branch confrontation over institutional prerogatives. Legal experts stress that emergency seizure orders are inherently temporary and subject to modification, and that forthcoming arguments would determine whether the measures remain in place or are narrowed, making upcoming court sessions critical inflection points. The broader constitutional questions now dominating discourse include whether voluntary waiver of spousal privilege in such a high-profile context establishes precedent for future cases, whether rapid judicial intervention signals a shift toward more assertive oversight in disputes involving executive authority, and how the interplay between personal liability, advisory responsibility, and institutional accountability will evolve as facts continue to emerge. Throughout it all, commentators have cautioned viewers to distinguish between allegations, interim protective actions, and final adjudications, reminding the public that seizure does not equal guilt, and testimony does not equal conviction, but rather represents a stage in a complex adversarial process designed to test evidence under rigorous standards. As additional filings are anticipated and both sides prepare further arguments, the nation watches a rare and dramatic intersection of family, finance, and constitutional law unfold in real time. A reminder that in the United States system, even the most powerful offices operate within a framework of judicial review, and that moments of tension between branches, while destabilizing in the short term, are also part of the structural design intended to prevent unchecked authority. Whether this episode ultimately results in narrowed executive interpretations, strengthened privilege doctrines, expanded forfeiture tools, or simply a reaffirmation of existing precedents remains uncertain. But what is clear is that the combination of sworn testimony at the highest court, immediate enforcement measures, and visible fractures in political unity has created one of the most closely watched legal sagas of the decade. And as hearings proceed and legal briefs multiply, the only definitive conclusion at this stage is that the constitutional system is being stress-tested under extraordinary public scrutiny, with outcomes that could shape interpretations of executive power, marital privilege, and judicial authority for years to come.